Thanks, Mary Kate. Hello, everyone. My name is Kelly Head, and I am a staff attorney here at ASISTA. I'm presenting today's webinar on intermediate and advanced U visa issues with my colleague, Amy Chung, ASISTA's Senior Legal Counsel. We'd like to take this opportunity to thank OVW for their generous support of our training and technical assistance work. Without their support, today's webinar would not be possible. A few housekeeping matters before we begin. ASISTA sent the slides and the index of materials to all attendees before the webinar. This webinar is being recorded, and the recording will be sent to all attendees after the webinar. The webinar has been approved for 2 CLE credits in Texas. If you are barred in Texas and you would like CLE credit, you should have already put your bar number in your registration materials, but if you have not done so, after the webinar, you can email ASISTA's program associate, Maria Lazzarino, with your bar number information, and her email is at the end of the slide deck. If you're not barred in Texas, but you want to request CLE credit to request a certificate of attendance on your own behalf, you can email Maria after the webinar to request a certificate of attendance. And again, please feel free to put your questions in the Q&A box, but we will be waiting to answer questions until the end of the webinar. And with that, we'll begin today's presentation. Next slide, please. So today, by participating in this webinar, we have 3 learning objectives. The first is that you will better be able to understand the definition of victim for U visa purposes. The second is that you'll be better able to demonstrate that your client is considered a victim for U visa purposes. And finally, you'll be better able to determine when a Form I-539 is necessary for a U visa client. Next slide, please. And for today's agenda, we'll be starting with the definition of victim in U visa cases. We'll first talk about this concept of direct victim and how federal courts have handled the definition of victim, as well as how the USCIS, or the DHS Administrative Appeals Office, considers the concept of direct victim. We'll then move on to the concept of indirect victim, and then we'll talk about I-539s, including their legal basis and common scenarios when I-539s are necessary. And then we'll have about 20 minutes at the end to discuss participants' questions. Next slide, please. So we're going to dive right in with the definition of victim. Next slide, please. So being a victim of a qualifying crime is, of course, a threshold requirement for obtaining a U visa. So it's really important to understand who can be considered a victim for U visa purposes. And as you can see on the slide, the victim requirement comes from the statute, which requires that the non-citizen has suffered substantial physical or mental abuse as a result of having been a victim of a qualifying crime. But as you can see, the statute doesn't define the term victim. The definition of victim comes from the regulation, and the regulation focuses on whether the non-citizen has suffered direct and proximate harm as a result of the commission of the qualifying criminal activity. So this concept of direct and proximate harm is what we're going to be focusing on today. There's also a part of the regulation that defines certain family members of direct victims as indirect victims, but we'll be discussing that later in the webinar. Next slide, please. So we're going to start out with a discussion of this concept of direct victim. Next slide. So a lot of our discussion of this concept of direct and proximate harm today will focus on this case, Mars versus Nielsen, and a lot of the content for the subsequent discussion and some of the citations will come from that case, and that case, a link to that case is included in your materials. Another really great place to look for more information about this concept is ASISTA's amicus brief on the direct victim definition, and a link to that is also in your materials. So Mars was a district court case out of New York from 2019, and its 2 holdings were that the U visa regulations unambiguously adopt the well-established legal meaning for direct and proximate harm, and second, that the established legal definition of that term does not require physical presence. Next slide, please. An important portion of the Mars holding is that this term, direct and proximate harm, is a term of art. So why is this important that it's a term of art? Mars cites this case from the Supreme Court, which itself has cited some other precedent cases from the Supreme Court, holding that it is a cardinal rule of statutory construction that when Congress employs a term of art It presumably knows and adopts the cluster of ideas that were attached to each borrowed word in the body of learning from which it is taken. That said, of course, this concept of direct and proximate harm comes from the regulations and not from the statute. So can this tool of statutory construction that was in the Supreme Court case, can it be applied to regulations? Mars considered this and they held that it could, and they cited 2 different circuit court cases where the court applied tools of statutory construction to regulatory interpretation. And the citations for those cases are on the slide, and there's also links to them in your materials. So it's really important to consider this holding about this cardinal rule of statutory construction, because if this concept, direct and proximate harm, is a term of art, it means that the drafters of the U-Visa regulations, where this term applies, must have known and adopted this cluster of ideas that existed around this term, direct and proximate harm, at the time that the U-Visa regulations were drafted, and use that cluster of ideas to determine what this term means. So what exactly are these cluster of ideas that surround this concept of direct and proximate, and where do they come from? The answer to that is that they come from case law, some of which is well over 100 years old. Next slide, please. So the case law focuses on whether, when defining this term direct and proximate, they focus on whether there's a connection, an unbroken connection between the act and the injury, whether there's a continuous operation between the two. They focus on whether the damages are directly traceable to the triggering event, and whether there's other intervening causes, or whether there's too much remoteness between the triggering event and the damages. And again, you'll see that many of these cases are well over 100 years old, establishing the fact that this does have a very well-established meaning, this concept. And you can see that the universal focus of this case law is on showing a connection between the triggering event and the injury, with an additional consideration of alternative causes. Next slide, please. Some additional ways that the term has been interpreted in case law is a consideration of but-for and proximate causation. The Second Circuit had held that in the case that's cited here in the slides. There's a focus on whether there's attenuation, which is consistent with the slides that were cited, the cases that were cited in the previous slide. Really important for our purposes is that there's this focus on foreseeability. United States versus Sharp, which is the case that's cited here, it held that foreseeability is at the heart of proximate harm. And that's really important for our purposes because US versus Sharp interpreted the Crime Victims' Rights Act. And that statute was cited in the preamble to the U-Visa regulations. And in the preamble, the authors had stated that they drew this regulatory definition of victim from established definitions, including the definition at the CVRA. And the CVRA's definition of victim uses this exact same phrase, direct and proximate harm. And we see from Sharp that foreseeability is at the heart of proximate harm. And again, you'll notice that a lot of this case law existed before the time of the U-Visa regulations enactment. Next slide, please. That said, what about bystanders and what about this example from the preamble? A lot of you are likely familiar with the language in the U-Visa regulation preamble about a pregnant woman who witnessed a crime and she became so distraught from witnessing the crime that she suffered a miscarriage. So does the fact that that language is in the preamble, does that mean that this phrase of direct and proximate harm should somehow be interpreted more restrictively in the U-Visa context than it is in other contexts? Mars considered this question and they held that that's not what it means. They had held that the example is insufficient to overcome, again, what is this clearly established meaning from case law of direct and proximate harm. They've said that the preamble is a persuasive evidence of its the purpose of the regulation, but that it is not actually part of the regulation. They've said that the example can guide the agency's decision-making, but it does not create a strict rule. And that's really important for our purposes because as Mars holds, if the language of a preamble is not part of the regulation, This means that this pregnant woman example, this concept of bystander, that's not actually in the regulation itself. That's only in the preamble. If we're focusing on what the regulation requires, the only requirement is direct and proximate harm. Next slide, please.
Before we move on, I was wondering if we could back up a little bit and talk a little bit more about the facts of Morris v. Nielsen and why it was necessary to litigate in federal court whether or not this person was actually a victim of a crime in the first place. Because I feel like in the vast majority of U visa cases, it's not so much a question of whether the person is a victim, right? Like there are all kinds of other issues that come up, but it's not quite as common for USCIS to say, well, we don't think your client was a victim of this crime at all. So why was it so important? And why does this issue have broader applicability?
Right. So in the facts of Morris v. Nielsen was that the petitioner for the U visa was the mother of a adult daughter who had been murdered by her ex, her co-parent, and the mother was not present at the time of the daughter's murder. And USCIS had said, and the AAO agreed, that she was not considered a victim of the crime of the daughter's murder because she was not present at the time of the murder. And it's the case's reasoning is broadly applicable because there are many instances when people, for example, close family members are victimized by a crime and the petitioner was not actually present at the time of the crime, but has suffered substantial harm from that crime.
And I think one of the key facts here is that the daughter who died was an adult, right? She was over 21 at the time of the crime, right? And so that's why her mother was not eligible to file as an indirect victim, which is normally what you would do if the person who was killed was under 21.
Great.
So thank you.
Thank you. Next slide, please. So we've talked about how a federal court has defined this concept of direct and proximate harm. We've talked about how federal courts have interpreted this term for other purposes, for the purpose of a statute that was cited in the U visa regulation preamble. But how does the AAO consider this issue? In a lot of these cases where someone who often was not present at the time of the crime is trying to argue that they should be considered a victim, the AAO has a very uniform response, uniform set of language in all of their cases where they talk about their position on this. So their first argument that they make is that they're not obligated to follow Morris versus Nielsen, and they say that's because Morris is a district court decision, and their position is that they're only obligated to follow precedential appeals, Circuit Court of Appeals decisions. The second is that despite all of this case law and this uniformity in the interpretation of this concept of direct and proximate harm, they hold that this term actually is what they call genuinely ambiguous. And the AAO says that because of that, this term is subject to reasonable interpretation. They also, when they're talking about the Crime Victims' Rights Act, they say that that act does not address U visa eligibility, and that it was also not cited in the INA or in the U visa regulation. They also make a lot out of the existence of the statutory cap. They say the fact that this cap exists, that only 10,000 principal U visas can be granted every year, demonstrates that there's an intent to limit U visa eligibility to only certain people who were victims of a crime, rather than anybody who was simply impacted by a qualifying crime. They make a lot out of the treatment of the concept of bystanders in the preamble. They say that in the preamble, USCIS explained that this bystander relief is generally only available to people who were present at the time that the crime was committed. They also say that USCIS did not intend for all but for and reasonably foreseeable harm to be included in this concept of direct and proximate harm. And finally, that USCIS has the discretion to treat certain non-citizens who were not targeted by the crime as victims. So they're saying that this determination of whether someone who is not targeted is a victim is a discretionary determination for USCIS. Next slide, please. So there are some arguments that we can make against the AAO. The first is that, as demonstrated by the really long line of case law that goes back over 100 years, there is this settled meaning of direct and proximate harm, and that the Supreme Court holds that when a concept is a term of art, that the people who draft the law that includes that concept know about the cluster of ideas surrounding it. And I've cited here the case of Medina Tovar. Most of you are likely familiar with this case, which held that the U-Visa regulation that required the relationship with a derivative family member to exist at the time of filing was an impermissible interpretation of the statute. The reason I have it cited here is that a lot of the reasoning in this case talks about the responsibility of how legal language should be interpreted when it has a settled meaning. In Medina Tovar, a lot of the reasoning was about this term accompanying or following to join, and the court held that that term had a settled legal meaning, and because of that, it had to be absent like an express carve out from the statute, it had to be interpreted in a certain way. So for those of you who are in the Ninth Circuit, you could cite Medina Tovar and emphasize for USCIS that it is a precedent decision in your circuit, and its reasoning about how terms with settled meaning should be interpreted is also precedential in your circuit. And then you can also cite that Ninth Circuit case that concepts of statutory interpretation, like the ones that were applied in Medina Tovar, can also be regulatory as well. Second, that they talk about the established meaning of direct and proximate is actually consistent with the AAO's concern about only victims being eligible for U visas. So like we've talked about, this concept of direct and proximate harm goes to whether someone is a victim, not to whether they are simply impacted by a crime. So if someone has been directly and proximately harmed by the crime, they are necessarily a victim and not just impacted. So we're talking about people who are victims. It's also important to do a close reading of the preamble. Nowhere does the preamble actually say that the bystander has to be physically present or in fact even close by in order to qualify for relief. The focus of the preamble is on unusually direct injury. So it's important to read the preamble closely and not to just take the AAO at their word. You'll also notice that if you read the preamble closely, that they say that the pregnant woman example is just an example of unusually direct injury. They don't say that it is the only example. And they also, when you read the preamble closely, you'll see that USCIS, nowhere do they say that they do not intend to include all but for and reasonably foreseeable harm in the definition of direct and proximate. That statement just simply isn't in the preamble. While the preamble does talk about the fact that these Attorney General guidelines, which the preamble said were an informative resource when developing the victim definition, they do talk about the fact that those guidelines say that injuries that arose only indirectly from an offense, people who experience those are generally not entitled to services as victims. But when you think about it, that's actually not a departure from this established definition of direct and proximate, because that still requires a showing of foreseeability and a showing of a clear connection between the injury and the crime itself. The term discretion, responding to their argument that the decision of who is a victim is discretionary for USCIS, the term discretion does not appear in the U visa statute itself, and its mention of the concept of victim and the regulatory definition of victim also does not include this term discretion. While the preamble does mention discretion, again, like we've talked about, the preamble is not part of the regulation. That said, though, we want to get these cases approved if possible at the USCIS or AAO level. So we're going to talk about some tips that practitioners can use to get their cases approved at one of these levels. Next slide, please. So the AAO has, despite this this issue in Mars versus Nielsen, where the mother was not present at the time of the crime, the AAO has approved some cases where the petitioner was claiming to be a victim, but they were not actually present at the time of the crime. So what are some common factors that were present in these decisions? I'll preface this just by saying that these were non-precedent decisions. So it means that the AO isn't obligated to follow them in future cases, but to the extent that a pattern can be drawn, a lot of these cases, the petitioner was aware of some sort of a risk to the targeted victim before the crime occurred. And that awareness of risk might have also been accompanied by an unsuccessful attempt by the petitioner to try to mitigate the harm to the targeted victim. In some of these cases, there was evidence that the perpetrator had previously threatened the petitioner. In some of these cases, there was evidence that the petitioner and the targeted victim had a particularly close relationship. Next slide, please. In a lot of these cases, the AAO had characterized the crime that was committed against the targeted victim as particularly cruel or violent. In these cases, even though the petitioner, again, was not actually physically present at the time of the crime, there was evidence in the record that there was some sort of proximity to the crime. Like the petitioner, even though they weren't present when the crime occurred, they were nearby, or they heard, for example, gunshots. In a lot of these cases, there was evidence that the petitioner, although they weren't present when the crime occurred, they saw the targeted victim's injuries in the aftermath of the crime. And finally, which is really important in these cases, the petitioner's injuries were very clearly tied to the qualifying crime. Next slide, please. Can we go back one, please? Thank you. So because of these different factors, what are some practice tips for practitioners? First is to take a multi-pronged approach. So in every case, you always have to show evidence of harm to the petitioner, even though they weren't the targeted victim of the crime. And that's because if there is no harm, the client wouldn't be considered a victim under any definition, right? Because even the regulatory definition of direct and proximate harm requires harm. So you have to show evidence of harm. And remember that most of you probably already know this, but statements of counsel are not evidence. So if you want to show that your client was harmed, if you want to show that something occurred or is true, you have to show it through, for example, a statement from the client, from medical records, police reports. So keep that in mind. Assuming you've shown evidence of harm in the record, you can make two separate arguments. You could start by arguing, the only requirement is direct and proximate harm according to the regulation, making your arguments about how that term has been interpreted, and then connecting the facts in your case to make the argument that your client has been directly and proximately harmed. And to do that, you would focus on but-for causation as well as proximate causation and accounting for any alternative causes or remoteness. But if you want to get the case approved at the AAO or the USCIS level, where they're really, unfortunately, not very receptive to these arguments, you would also try to analogize your client's case as much as possible to these approved AAO cases and show that the facts and the evidence in the record are similar enough to these cases that your client's case should be approved. So to the extent, for example, that any of the factors that were listed on the previous two slides apply to your client's case, you would include evidence and highlight in your brief or cover letter that those factors were present, and you would attach the favorable AAO decisions that are similar to your client's case to your submission. And detailed client interviewing is really important in these cases because you want to use interviewing to determine if the facts show that both that the client's harm was a but-for consequence of the crime, that the client would not be experiencing this harm that they're currently experiencing if the crime hadn't occurred. And you want to consider with client interviewing whether the harm that the client suffered is foreseeable given the crime. And you also want to be using client interviewing to determine if any of those factors that have been present in the previously approved AAO decisions are present in your client's case. And a particularly important question to ask is if your client is receiving mental health treatment, and if so, why, determining whether there is a connection between the need for the treatment and the crime, and if they've received any diagnosis, whether there is a connection to the crime and that diagnosis. You want to be analogizing to the favorable AAO cases. One of the elements that's in those cases that I wanted to talk about is this statement that the crime was particularly cruel or violent. So in the AAO, there was one of the AAO cases where they suggested that if the targeted victim, so the person who the crime was actually committed against, if they had some sort of a pre-existing vulnerability, that could make the crime particularly violent or cruel. So there was an example of a case where the targeted victim was a baby who was abused by its father, and the petitioner was the baby's grandmother, and she couldn't be an indirect victim because she wasn't the parent of the baby at the time of filing. And the court focused, that the AAO focused a lot on the fact that at the time of the crime, the baby was a premature infant who had just come home from the NICU. So to the extent that you could show that there's some sort of a pre-existing vulnerability in the targeted victim, that's something you can focus on. Also in these cases, a lot of the AAO decisions that focused on the fact that the crime was particularly violent or cruel, they focused on evidence such as police reports or probation reports or medical records from the targeted victim that went to the particularly violent or cruel nature of the crime. So to the extent you could get these documents with the client's permission, that is a way to sufficiently analogize your client's case to these approved cases, but without re-traumatizing the client and asking them to recount, the facts of this horrific crime unnecessarily. Relatedly, if the client is seeing a therapist, you could talk to the therapist and see if the client has already shared with them facts about the case. And then if they have, the therapist could include that in their letter. And that is another way to show that your client's case is sufficiently similar to these AAO cases that have been approved. Including vivid descriptions of the client's injuries is really important. For example, if the client says, I'm depressed, that's not going to be nearly as effective as the client saying they're depressed, to the extent it's true, of course, connecting it to the crime. And then for that client saying for them what depression looks like, because you'll see if you look at these AAO cases that are linked in your materials, there was a lot of detail about how the crime impacted that particular person's day-to-day life. Like there were some people who had said that they were no longer able to socialize. There was someone who had said that she could no longer live in her home because that's where the crime occurred, that she could no longer nurse her infant. So as much as possible that you're able to get those really vivid, good details in, that's really important to do. And finally, I think the most important practice tip that you could take away from this is that you have to very clearly connect all of the client's harm and injuries to the qualifying crime. And that's important because no matter what definition you use of victim, you have to show that there is this connection between the injuries and the crime, and that there's not too much attenuation, and that there's foreseeability. And a way to do that is, for example, a mental health evaluation would have to very explicitly explain that the client's symptoms have arisen from this crime. A mental health evaluation that said something like, the client had a difficult childhood, they witnessed violence in the home country, and now they have depression, that would not be very effective because there's no indication there that the client's injuries are a result of the crime. And similarly, if the client has a pre-existing mental health diagnosis, you would need to show how the qualifying crime has exacerbated any of the symptoms of that diagnosis and be really explicit about the connection between the exacerbation and the qualifying crime. Otherwise, USCIS might find that there's just not a sufficient connection to render the person a victim. Next slide, please. So we have a hypothetical here. We have Cassandra. She recently called your office for a U visa intake. She said that her 25-year-old daughter, she's always been close with her. Her 25-year-old daughter's husband recently shot her during a child custody exchange. The shooting left the potential client's daughter paralyzed, and she now requires 24-hour care. Cassandra is cooperating with the law enforcement investigation of the shooting, and she is in therapy. So what questions would you ask Cassandra to determine if she can be considered a direct victim? And are there any additional questions that you would ask if you want this case to be approved at the USCIS and AAO level? So I'll give folks about 5 minutes to answer this, and please feel free to put your answers in the chat.
A lot of folks are putting their ideas into the chat. I think it's, this is an argument that we've been pushing over the last few years, and I think has gained some steam, particularly in the aftermath of Morris v. Nielsen. And I think it poses a lot of possibilities for expanding U visa eligibility for people who you might not normally think of as being U visa eligible, right? And in these examples that we're talking about with Morris v. Nielsen, and in this hypothetical, we are talking about domestic violence situations where a parent of the most directly impacted person is trying to file for a U, but it has wider applicability as well. And I think when you're talking about different situations where the potential U visa client is maybe not related to the person who was most directly impacted, it poses additional challenges with the AAO because, as Kelly said, USCIS is very resistant to these cases. But the possibility of making the legal argument is there.
Okay, thank you, everyone. Everyone has some really great ideas here. Kathleen asks where Cassandra was at the time of the shooting, if she's more of a caretaker now because of the daughter's injuries. Catherine talks about, as she's mentioned in the police reports. Avisa asked if she was present when the husband shot the daughter, as well as foreseeability of harm. Continue cooperation with the authorities. If she's been threatened, Cassandra's been threatened by the son-in-law. If there's risk of harm to the extended family. Elizabeth asks if she's witnessed any of the violence against her daughter previously, how the crime has affected her. Did she quit her job to care for her daughter? So these are all really, really good questions, and thank you everyone for that. Just to add to that, in terms of where she was at the time of the shooting, of course, the most obvious question is, did she witness the shooting? But even if she didn't, was she close by? Did she hear any gunshots? Did she see her daughter's injuries immediately after the crime occurred? Was she present when her daughter was receiving medical treatment? The case with the baby who was abused, the grandmother had not actually seen the abuse occur, but she did see the child's injuries after the abuse, and she was present when the child was receiving medical treatment. Folks who talked about impact on Cassandra of caring for the daughter, that's really important to consider as well. Is she the one who is caring for the daughter? Is she caring for the daughter's children now. The case again with the baby, there was evidence in the record that the grandmother was now the primary caretaker of that baby and was responsible for caring for the baby's injuries. And there was evidence that that caretaking responsibility was emotionally and physically exhausting for the grandmother. So to the extent that Cassandra could show that type of evidence, that would be helpful. Is there documentation of the daughter's injuries that could be used to show that this crime was particularly violent? I mean, just, the description makes it absolutely makes that case, but is there any other documentation of the injuries that could be used for that? And then also people had talked about if there was abuse of the daughter by the ex before the crime occurred. And that's really important too, because in some of these cases, there was evidence of previous harm to the direct victim, that targeted victim that the petitioner had known about previously. So you'd want to be asking, did Cassandra know about the risk of harm to her daughter? Had she tried to stop the harm? For example, had she taken the daughter to a domestic violence shelter? Had she tried to help her file a protective order? All of those are really good questions to ask. And then also, we've noticed that she's in therapy, but it's unclear why she's in therapy. So you'd want to be asking her why she's in therapy, if she has any diagnosis, and if there's a connection between those and the crime. And then you would also want to be talking about the foreseeability of her injuries, which someone had mentioned, which is really important. I would say if the ex knew that Luz and Cassandra had that really close relationship, given the extent of the injuries and the cruelty of the crime, I think harm that the mother had suffered would be pretty foreseeable. Amy, what do you think about if for some reason the ex didn't know that Cassandra and Luz had this really close relationship? Do you think that there's an argument that her injuries are still foreseeable?
I mean, I would probably make the argument that shooting and paralyzing a person would have foreseeable impacts on anybody who is, related to or close to this person, regardless of whether it was an especially close relationship. There's always going to be, I would say that there's always going to be foreseeable effects coming out from, the epicenter of the crime, right, which is Luz. So there's going to be an expanding radius of people who are affected by this. And I don't know that we need to show that this person specifically was intended to be harmed by the perpetrator in this event. So I think I would make the argument that it was foreseeable that anybody who was close to her would have been affected by this, and that Cassandra happens to be one of those people.
Great. Thank you. And Diego had asked, what is the qualifying crime? The shooting. So, right, whoever was representing Cassandra would have to argue that the shooting was a qualifying crime, either attempted murder, felonious assault, however it would be phrased in that state.
Or even domestic violence.
Or domestic violence, right?
But I think like the magic of this argument is that you are arguing that Cassandra, who was not shot and who may or may not have a qualifying relationship to the perpetrator for domestic violence purposes, is actually a direct victim of this qualifying crime, right? Like that is the I think the exciting part of this kind of argument.
Mm-hmm. Great. Next slide, please. So now we're going to move on to indirect victim, which is a concept that is a little bit more common and familiar to people. Next slide, please. So the concept of indirect victim comes from the regulation 8 CFR 214.14A14. And the threshold question with any indirect victim case is how old is the direct victim? Because the age of the direct victim directly determines who is going to be the indirect victim. So if the direct victim is under 21, then in addition to the spouse and the children of the direct victim, their parents and their unmarried siblings who are under 18 can also be included as indirect victims. Whereas if the direct victim is 21 or older, the only people who could be included as indirect victims are spouses and children under 21. So you see here that the dependency is on the age of the direct victim, and also that only people with certain established family relationships can be considered indirect victims, which is why this concept of direct victim and expanding this definition is really important, because who can be an indirect victim is remarkably limited under the regulation. And because the direct victim's age is so important, you might be wondering, when is this age measured? The regulation is pretty clear that the age of the direct victim is measured at the time of the crime rather than the time of filing. Next slide, please. So we talked about how the indirect victim has to have certain family relationships with the direct victim. So the question is, when does that family relationship measured? So there was a non-precedent AAO decision. So again, it does not have to be followed in future cases, but I thought it was interesting and I wanted to highlight it for everybody. There was this case from March of 2020 where they found that there was no requirement in the INA or in the U visa regulations that the family relationship needed to exist at the time of the crime. The holding was that the family relationship only needed to exist at the time of filing. And that was important in this case, because in this case, the petitioner was an adoptive parent of a child victim, but the adoptive relationship did not exist at the time of the crime. The AAO held that the legal basis for this statement, that the parent only had to be the parent at the time of filing, was this regulation listed on your slide here, which holds that only the for every immigration case, the petitioner or the beneficiary has to establish eligibility at the time of filing. And the relationship is measured under the INA standards. And in this case, because it was an adoption, the AAO made reference to the statutory definition of child and parent in cases where the child was adopted. So what I would say about this case is that if your petitioner has an adoptive relationship with the direct victim, make sure you read that adoption statute very carefully and make sure that you have a really firm legal argument before filing that this relationship exists at the very least at the time of filing, and letting clients know that because this is not a precedent decision, there's always a chance that the case could be denied if the relationship did not exist at the time of the qualifying crime. Next slide, please. So with indirect victims, of course, we've talked about age of the direct victim and as well as certain family relationships, but these are not the only considerations. In addition to those two questions that you need to be asking in every case, you also need to consider whether the direct victim is either deceased due to murder or manslaughter, or whether they're incompetent or incapacitated. So the question is, are direct victims of a certain age always considered incompetent or incapacitated? The AAO's position, which they've expressed in multiple non-precedent decisions, is that there's this presumption that direct victims who are under 16 years old at the time of the crime are considered incompetent or incapacitated. And their justification for that is the U visa regulation, which allows victims who are under 16 at the time of the crime to have a parent, guardian, or next friend cooperate with law enforcement on their behalf or possess information on their behalf. The USCIS position is a little bit more generous, actually. It's that unmarried victims under 21 are incapacitated due to age. The reason I have an asterisk there is that these documents came from the results of a FOIA lawsuit that ASISTA and some other groups had filed. These documents were part of a USCIS standard operating procedures from 2020. These results are linked in your materials, but it is unclear, first of all, whether this is still USCIS policy. And even if it is, we may not know whether USCIS changes this policy. So we would encourage folks to be aware of this policy that exists in these documents, but also advise clients that we're unclear if this is still the policy, and let them know that, for example, if you have a direct victim who was, say, 18 years old, but also helped, for example, with the law enforcement investigation, and there's not a lot of really great arguments that they were incapacitated, letting the indirect victim know that there's a chance of denial in that case. Next slide, please. So the question is, what about a direct victim who did somehow participate in the investigation or the prosecution of the qualifying crime? Are there ever any circumstances when those direct victims can still be considered incompetent or incapacitated, which would allow a family member to, certain family members to qualify as indirect victims? So the AEO has in some cases found that these people are incompetent or incapacitated. Some factors that the AEO has focused on in their decisions are the level of participation in the investigation of both the direct and indirect victim, whether the direct victim has any mental health issues, and particularly whether those mental health issues had impacted the direct victim's ability to cooperate, and whether they're related to the qualifying crime. Whether the direct victim needed any type of support in order to cooperate, like, for example, if they needed someone to take them to interviews with law enforcement, someone to help them prepare to testify, if someone needed to encourage them to cooperate with the investigation, as well as the indirect victim's role in supporting the direct victim. And then one of ASISTA's suggestions also is to consider laws in the client's jurisdiction about the incompetency or incapacity of minors in certain legal situations. So if in your client's jurisdiction, there is a law that says, for example, minors under 18 are incompetent or incapacitated in certain situations, you may wish to argue that because of that, despite the fact that the child victim, for example, may have cooperated, the law in the jurisdiction holds that they're still incompetent or incapacitated. Next slide, please. So this hypothetical is derived from an AEO case where they found that a 17-year-old child victim who had cooperated with the law enforcement investigation of the crime was nevertheless incompetent or incapacitated. So we have the child victim who is now 22 years old, but when he was 17, he was the victim of domestic violence by his boyfriend. He initially did speak with the police about the crime, but then declined to testify because of mental health issues. The father of Jose did testify in the criminal case, and there's evidence that that Jose's boyfriend had abused him for years before the crime, and that he was actually hospitalized because of this. So my question for folks is, first, a review question. Does it matter that now the direct victim, Jose, is 22 years old? And second, what facts would you highlight in any argument that Jose is incompetent or incapacitated? So I'll give folks a couple minutes to put that in the chat. Okay, so I saw that someone had said the age at the time of the qualifying crime. So are you okay to file now? And that's correct. It does not matter that now he is 22 years old. In this AEO case, they had highlighted a few factors in support of the direct victim's incompetency or incapacitation. They focused in particular on the fact that the child victim had serious mental health issues both before and after the crime. They made a lot of the fact that the child victim's mental health issues were serious enough that they required hospitalization, that they had been exacerbated by the very qualifying crime that is at issue in the U visa, that the mental health issues were the reason that they weren't able to participate in the investigation or prosecution. And they also focused on the age of the victim, even though they didn't qualify for this presumption because they were over 17 at the time of the crime. Yes, others had talked about state laws. That's really important too, definitely to consider mental health issues of the direct victim, inability to cope with what happened due to the abuse, extensive trauma that precluded cooperation, right? So those are all really great arguments, I think, to be making. So I would just say in these cases, when there is, I would make sure you're always asking the questions about the age of the direct victim, the family relationship, and incompetency or incapacitation, to be considering the factors in this case, which is linked in your materials, as well as the other cases where younger victims were found to be incompetent or incapacitated, and let that guide your client interviewing in these cases.
I would also say that even though it's not entirely clear how USCIS is following this policy about everybody under 21 being incompetent or incapacitated, as we see in these AAO cases, right? Because obviously if that were the case, these cases would never have had to be appealed to the AAO in the first place. If you're getting an RFE on these issues, I would print out a copy of that USCIS policy language from the SOP and include it in your response. As support for the idea that they are violating their own policy by requiring anything other than proof of age for this person who was under 21 at the time of the crime.
Thanks, Amy. So we're going to move on to the second part of our webinar, I-539s. Next slide, please.
Great, thanks, Kelly. All right, so now we are talking about a very, very different topic. So for the next part of today's session, we are assuming that the U visa has already been granted, right? And now we're talking about how long does that person's status last, and under what circumstances might you need to extend that person's status, and why is it even possible at all to extend non-immigrant status? Okay, so we're going to start off with the basis for why this is possible, and then we're going to walk through some common scenarios where you may find that filing a 539 is necessary. Okay, so for the basis, there is a statute that says that USCIS can, and in some cases must, extend non-immigrant status, right? And so this is why USCIS is able to do it at all. There are two main reasons why they would be able to extend status. So the first, which is much less common, is that the law enforcement agency signs a certification saying that this person's presence in the United States is required to assist in the investigation or prosecution. This is not a very common scenario. You know, certainly if you have those facts and you are able to get a certification, that's great, do it. It'll be a very straightforward 539 for you. But I would say that in the vast majority of cases that we see, we're really talking about the second scenario, which is that DHS may extend, right? And so here's a key difference between shall be extended upon certification versus may extend. Beyond the 4 years that they're originally authorized, if they determine that an extension is warranted for exceptional circumstances, okay? And so in most of these cases, if you don't have a certification from law enforcement saying that the person's presence is necessary and you need to extend that person's status for some reason, you will need to show exceptional circumstances. And we're going to talk a little bit later about what exceptional circumstances might be. Okay, so next slide, let's talk about when 539s might be needed. And so these are some of the most common scenarios where we see them. One is that the period of the non-immigrant admission is less than 4 years. This is particularly common for derivatives, especially U2s, U4s, and U5s. Sometimes if the derivative application or petition is filed after the U1s is already approved, or it was just delayed in processing for some reason, sometimes they'll only authorize a period for those derivatives for less than 4 years because they want the expiration to coincide with the principal's expiration. This can also happen when folks are consular processing, if it takes a while to consular process. Another common scenario that we see is that for whatever reason, the client just was not able to file their adjustment of status application on time. And so their non-immigrant status has already expired. They haven't filed for adjustment yet. And under those circumstances, you would have to file a 539 to restore the client's non-immigrant status so that they can be eligible for adjustment. And this is because USCIS requires that the adjustment applicant be in non-immigrant status at the time of filing the 485. Another really common scenario is that one of the derivatives has not yet consular processed and the principal status is expiring. And so you would need to extend the principal status in order for the derivative to complete consular processing, or any other situation where the U visa client is unable to file the 485 timely, or they just need this extension for reasons that are consistent with the goals of the statute. Okay, so there are all kinds of reasons. I would say the first three are going to be the most common scenarios that you will see in cases. So what do you need to show? Let's go to the next slide. So if you are trying to show that the U visa client's presence is necessary to assist in the investigation and you get a certification, then you need a certification, right? And you don't really need anything else. The statute doesn't require anything else. You would not need to show exceptional circumstances in that instance. For the majority of cases, you need to show exceptional circumstances. And so some arguments that we've seen be very successful to show exceptional circumstances have included that the U1 can't adjust yet because the derivatives have not consular processed. And so the U1 needs to extend their own status. Another one is ineffective assistance of counsel. And this is particularly relevant in cases where the non-immigrant status has already expired. Perhaps former counsel never told them when their status was expiring or what the significance of that was. Perhaps they had an attorney for the 485 who just didn't file it on time. There can also be notario fraud cases. All kinds of issues happen with timely filings of 485s. Another common issue that we've seen over the last few years is that when folks file the 485 with a fee waiver and they're filing very close to the deadline, if the fee waiver is denied, then the 485 would be rejected. And then by the time you refile, oftentimes it's going to be untimely. There could also be issues related to the trauma or the victimization that prevented the person from being able to act timely in filing their 485. So all kinds of reasons. If folks have other reasons that they have filed 539s in the past for exceptional circumstances, please feel free to share those in the chat. These are just some of the most common ones that we see at ASISTA. And in the statute, if you recall the language in the statute, it says that if you want to extend the person's non-immigrant status beyond the 4 years, you would need to show exceptional circumstances. But what about clients who are never issued 4 years to begin with? As you sometimes see, especially with derivatives, as we were talking about earlier. Kelly, do you think we would still need to show exceptional circumstances in those cases?
I don't think so, because I think the way the statute is phrased, it starts with, like you said, if you need to extend it beyond 4 years, you need to show exceptional circumstances. But arguably, if you haven't had it for 4 years, you shouldn't have to show that.
Yeah, I agree with that. I don't know exactly what USCIS does about this. And I will also say that they're quite generous about 539s for the most part anyway. And so it just hasn't been a big deal. But I do think that there is definitely an argument there. And I see in the comments that one person did one where the client failed to file timely, the 485 timely because of personal health issues. Absolutely. Also issues with I-94s and CBP. We're going to be talking about that in a lot more detail later on. And the fee issues as well, right? Where the fee waivers are being denied and 485s are being rejected. So yeah, I would say those are the most common scenarios, but they're all different kinds of circumstances where you could file a 539. And the argument that you want to make is that these are circumstances that are consistent with the goals of the U visa statute. Okay. Okay, so let's walk through some common scenarios and talk about some strategy. So let's go to the next slide. So in this scenario, your client, Radhika, was in the United States when her 918 was approved. So she is in non-immigrant status right now. And the validity dates on her 918 approval notice are October 1st, 2018 to September 30th, 2022. And so she's got just a couple more months. The problem is that her son, Ishan, has an approved 918A with the same validity dates as hers, right? So his 918A approval is expiring September 30th of this year, but he has not been able to consular process yet for whatever reason. And so what should Radhika do to ensure that Ishan can consular process as a U3? Okay, so we can pull up the poll. We can look at the options. All right, and so our options are that Radhika can file her 485 timely and ask USCIS to hold it in abeyance in order for Ishan to consular process. Our second option is that she should file a 539 for Ishan. The third option is that she can file a 539 for herself and ask for an amended approval notice for Ishan, or other. Just to let you know, if you pick other, I will ask you to share it in the chat because I'm curious what else you would suggest. Just going to give it a couple more seconds here. All right, let's go ahead and close the poll. And I'll share the results. Okay, so we've got a majority of folks saying file a 539 for herself and ask for an amended approval notice for Ishan. We've got some folks saying file a 539 for Ishan and some folks saying file a 45 timely and ask USCIS to hold it in abeyance. And we do have two others. So I will ask those two people to please share in the chat if you feel comfortable what else you would suggest so that we can talk about it. All right, and so with that, let's walk through the options and talk about the pros and cons. Okay, so let's go to the next slide. Okay, so first, let's talk about whether Ishan can file a 539 or whether Radhika would be able to file a 539 on his behalf. So if you recall, Ishan is not in the United States. He has not consular processed. He has not been admitted to the United States in non-immigrant status. Okay, so he has never been a non-immigrant, even though he has an approved 918A petition. The thing to keep in mind here is that an I-539 is used to either change from one non-immigrant status to another or extend existing non-immigrant status. And so the fact that somebody is outside the United States means that they are not currently in non-immigrant status. In addition, Ishan has never been in non-immigrant status. And so he would not be able to file an I-539. He has no status to extend. An I-539 in and of itself does not just extend the validity dates of a 918A. A 918A is a petition for classification to show that he's eligible for this U3 admission. But that in and of itself is not going to give him status when he's outside the United States. And so for this reason, Ishan is not able to file a 539 for himself. Radhika cannot file a 539 for him. Okay. And so that's why we need to look at our other options. So let's look at the next slide and we can talk about holding 485s in advance. So those of you who have practiced in the U visa field, we can go to the next slide, for a while, know that for a long time, if you had a U1 whose status was expiring and you had derivatives overseas who had not consular processed, you could file a 485 for the U1 You would not file a 539, right? Because if you timely file the 485, that automatically extends their non-immigrant status. And then you would ask the USCIS to please hold the 485 in abeyance to allow the derivatives to complete consular processing. And this policy was in place for a number of years. It worked quite well. And it avoided a lot of complications for folks, right? Because U1s wouldn't have to pay the filing fees for 539s, even to the extent that they were getting fee waivers. It was one less form that they would have to fill out, one less thing they would have to get an attorney to do for them. For folks who had private attorneys, they would save on attorney's fees, right? And it was one less thing that USCIS had to adjudicate. And so it really seemed like a win-win situation. However, USCIS has changed their policy. And for the last couple years now, they will no longer hold 485s in advance. When you file a 485, USCIS will adjudicate that 485. It'll take a long time to do it, but they're not holding it in advance. And the problem with this is that if the principal adjusts status before the derivatives have been admitted, the derivatives will now be ineligible to be admitted as non-immigrants. Okay, and this is because derivatives are accompanying or following to join the principal. And if you don't have a principal non-immigrant, you don't have anybody for the derivatives to accompany or follow to join. You may have a 929 for some folks, 929 option for certain derivatives at that point, but not everybody, right? And so there are folks for whom they would actually just completely lose eligibility if the principal adjusts before they are admitted as derivatives. Okay. And I will note here that there are some practitioners who will file a 485 without the medical exam in order to buy more time for the derivative, right? And the strategy here is that USCIS does require medical exams for non-immigrants who are applying for adjustment. That's another conversation, but they do. And if you don't include the medical, they will almost always send you an RFE for the medical. Particularly now with the COVID extensions, you've got 87 days for the RFE plus another 60 days for the COVID extension, right? It buys you a pretty substantial amount of time to get the medical in and try to complete consular processing. And so I will say that there are a lot of cases in which this is probably effective, that people have been able to avoid filing a 539 for the principal by timely filing a 485 without a medical and counting on this medical exam RFE process. However, one, this only buys so much time, right? And sometimes you don't know how long a consular processing case is going to take, especially with COVID. Certain countries have really not completely reopened yet. There are lots of not necessarily super foreseeable delays when it comes to consular processing. Some are foreseeable, some are not. And you just don't really always know how long it's going to take. And so you don't know how much time you need to buy with this process. The other thing that I will say is that in very, very isolated circumstances, I have seen USCIS accidentally approve U485s without a medical exam. And I really do think it's a mistake when they do this, but when they do it, what are you going to do? And what is your derivative going to do, right? And so I make a note of this because I think it's important to know about. I think it's important to be aware of. But I also think that there are certain risks inherent in pursuing that strategy. So now that we've established that filing the 45 and holding it in advance may not be the best strategy, what remains? Let's go to the next slide. Okay, so, and the majority of you guys did select this in the poll, so I'm very glad to see that. What USCIS wants people to do is for the U1 to file a 539 to extend the U1 status, and at the same time, request an amended approval notice for the derivative who needs to consular process. And this guidance comes from the I-539 form instructions. And so the top part of this slide is a screenshot of those instructions. So you can take a look at those. But the language here is that the extension cannot be granted to somebody who's outside the United States and has never entered in non-immigrant status. So a statement should be included with the application, and then an amended approval notice will be issued. Okay, so this is what USCIS wants people to do. Right, and so going back to the hypo, in this situation, Radhika would file a 539 for herself. And then because Ishan's 918A validity dates are expiring, or honestly, even if they were not expiring anytime soon, just to make sure, Radhika should include a statement with her 539 application requesting that amended approval notice. And I am curious, has anybody been able to get an amended approval notice through different means? Has anybody been able to get this without filing a 539 for the principal? Because that is USCIS's position on this, right? That's what USCIS says they want people to do. But I have occasionally heard that folks have managed to get them in other ways. Okay. Well, if anybody has done so, please go ahead and put that into the chat. I'd love to hear about what that experience was and how you did it, because this is really a really cumbersome and lengthy process for folks. And so if there are other ways that folks are doing this that has been effective, that would be great to share. And with that, let's move on to our next scenario. So let's talk a little bit more about Ishan. And so at this point, we are in the future. We have teleported, and USCIS has approved Radhika's 539. They have reissued Ishan's 918A approval notice. His new validity dates are October 1st, 2022 to September 30th, 2026. Ishan consular processes. He arrives in the United States on 10/1/2023. CBP stamps his passport, and then in his passport stamp it says admitted until, and they handwrite December 1st, 2024. Okay, and so what should Ishan do to ensure that he is able to adjust status as a non-immigrant? We're going to pull up another poll and walk through our options. And so Ishan's options are, he can file a 485 on or before September 30th, 2026. That's the expiration date on his amended 918A approval notice. Another option, he can file the 485 on or before 12/1/2024. That's the date written on his passport stamp. Or he can file a 539 to extend his status on or before 12/1/2024, or nothing. When Radhika files her 485, Ishan will be included as a derivative. I'm going to give it just a couple more seconds. Okay. I'm going to end the poll and share. All right, so we've got a mixed bag here. We've got some folks who are saying he should file his 485 on or before 9/30/2026, which is the expiration of his approval notice. Some folks saying that he should file the 485 before 12/1/2024. Other folks are saying he should file, sorry, we've got a little typo here. The third option should be file I-539 on or before 12/1/2024. So that the second and third options that show up on your screen are the same. So, and then the last option, nothing. We've got a couple responses there as well. So let's walk through this and talk about our options. I do see some interesting comments in the chat, which we will discuss. Okay, so let's look at the next slide. Next one, please. Okay, great. So what we are looking at here is, when is Ishan's non-immigrant status valid, and for how long is it valid, right? Because the idea is that he needs to either file a 485 before his status expires, or if he has less than 4 years or less than 3 years, he would need to file a 539 and then file a 485. Okay. So how long has he been admitted for? And the thing to know here is that if the person is outside the United States when the 918 or 918A is approved, that approval is an approval of their classification. It is not a grant of status. Okay, they are not actually granted status until CBP admits them into the United States. And so for that reason, the validity dates on the approval notice, the I-797, do not determine how long their status is valid. Okay. And this was a policy shift by USCIS. They didn't used to read it this way. But back in maybe 2018 or so, there was a radical shift in how USCIS was viewing this. And so the current interpretation is that approval notice, those are dates on the approval notice, do not determine how long the person's status is valid if that person was not in the United States when the approval took place. And so instead, what we need to look at is the I-94, because the I-94 is the record of admission that's issued by CBP. And it is that CBP admission that counts for figuring out when the status expires. Okay. And so in this instance, if we think back to the hypo, the passport stamp is what shows his admission. And we'll talk about the I-94 issue as well. But the passport stamp says that he has been admitted until December 1st, 2024. Okay. I would not necessarily rely just on this passport stamp. I mean, I think the most likely scenario is that his I-94 expiration is probably going to be the same as his passport stamp, but I would also try to get a copy of that I-94. The issue that we're seeing with I-94s right now is that CBP does not make them available electronically to non-immigrants because of confidentiality concerns. And so it's a little bit more complicated to get those I-94s. Options include accompanying the client to secondary inspection. The client can go alone. It's just, I think, difficult for some clients to explain to CBP what it is that they're looking for. And so you may have more success actually accompanying the client. Another option is to FOIA those CBP records. If folks have other ideas on how to get I-94s for non-immigrants that they've done, please share that in the chat. It would be great to know if there are other strategies that folks have. And so assuming that the I-94 dates do correspond with the passport date, then his status expires on December 1st, 2024, okay? Because that's how long CBP admitted him for. And so what that means is that he needs to file his I-539 before December 1st, 2024. He can't just file that 485 before the approval notice expiration date in 2026, because his status will have already expired by then, right? Based on this I-94. He also can't file the 485 by December 1st, 2024, because it hasn't been 3 years. He hasn't accrued 3 years of continuous physical presence because he entered in October 2023. It's only been a little over a year by December 2024. And he also cannot just rely on his mother's 485 because derivatives are not included in adjustment of status applications. Every single non-immigrant needs to file their own 485. Okay, let me just check the chat to see if we have other things here. Okay, so yes, thank you for everybody who noticed that the poll options were off, but hopefully we've clarified. Okay. And I do see that one person says that you can request an amended I-94 with CBP. And so I'd love to know more about that and whether you've had success in getting amended I-94s, because if we recall, the issue here, the reason why Ishan needs a 539 is because CBP only admitted him for a little over a year, right? From October 2023 to December 2024. And so if you were able to get CBP to amend his I-94 and give him the full 4 years, then I think that could also solve this problem. The reason why CBP often does give these shorter admission periods has to do with a number of things. Sometimes it's because the person's passport is expiring sooner, within 4 years. And you have this inadmissibility ground at 212A7B that you have to have a passport that's valid for at least 6 months beyond the period of admission. So sometimes that's the issue. And so some folks will have their clients get a new passport or make sure that they have a passport that's valid for at least 4 years plus 6 months at the time that they're consular processing, so that you don't have this problem with CBP. Sometimes it's also the issue is that the principal's status is expiring sooner. And so CBP will time the expiration of the derivative status with the principal status. So there are a whole number of reasons why this might happen. But if you can get an amended I-94, that could potentially work. Okay, and so Visa says that she's had success in getting amended travel records, but not experience with the I-94 is more of a suggestion. But if there are errors in the travel records, they're able to get them amended. Yes, sure. And yeah, if you have a good relationship with CBP, you can explain the situation, get them to fix it. That's potentially something worth exploring. And then once now that Ishan has been admitted to the United States, Radha can go ahead and file her 485. She doesn't need, well, she already has a 539, so she doesn't need another 539. She can go ahead and file her 485. And then Ishan's gonna go ahead and file his own adjustment later. Okay. All right, let's talk about another variation for Ishan. So next slide, please. Okay, so let's pretend that whole scenario we just talked about with Ishan didn't happen. He did not file a 539, okay? And so now it's July 2026. The expiration of Ishan's 918A approval notice isn't until, what was the date? September 2026, right? So based on that approval notice, it looks like he's still in status, but of course we know that his I-94 has expired, right? Ishan comes to you and he says he wants to adjust. And so now what should he do? Any ideas in the chat? We're not going to do a poll on this one. We're just going to talk about it. Any ideas for Ishan? So his U visa status has already expired. It's actually a couple years now after the expiration. You just got this case. What are you going to do to help him adjust? So Laura says Ishan should file an I-539 non-pro-tunc. Steli says the same thing. And yes. Ishan needs to file a non-pro-tunc 539. So let's look at the next slide. So the issue, as we said, is that his status has already expired, right? And it's not in the statute, but there is a regulation that the UAOS applicant needs to be in non-immigrant status at the time of filing the 485. I think that there are potentially arguments as to why this is incorrect or why the regulation could be ultra-virus to the statute, but bottom line, USCIS does require this. It's going to be much more straightforward and faster for Ishan to get this fixed if he files a non-pro-tunc 539 rather than fighting with USCIS about whether the regulation is ultra-virus. The problem with the 539 is that because his status has already expired, the 539 is being filed late. And so we call this non-pro-tunc. And with a non-pro-tunc I-539 filing, you do need to provide an explanation for why the 539 is being filed late. And you can see the reference for this in the 2016 policy memo on U visa extensions, which is in your materials. And so Ishan should include some kind of statement to accompany his 539 to explain why he didn't file on time. And I can think of a number of reasons why he might not have filed on time in this situation, right? Perhaps he didn't have counsel who told him when his status was expiring. Perhaps his counsel gave him incorrect information, right? Maybe they told him that his status actually expires in September 2026. And so he thought he was being really responsible in coming to you in July 2026 to talk about filing his adjustment of status application. And so you could have, ineffective assistance of counsel issues. You could have just a misunderstanding. And certainly there could be any other reason as well, right? So I think somebody else said earlier that the client had some personal health problems. It could be anything. And so he needs to include some kind of explanation. As I said earlier, USCIS is overall pretty generous when it comes to 539s, including non-proton 539s. So as long as you're providing some kind of reasonable explanation for something, there's I think a decent shot that it's going to work. We haven't seen too many problems with 539s being denied based on the reason, right? Based on the reason for the untimely filing or based on lack of exceptional circumstances. One exception to this is that if the client is in removal proceedings, and that includes people who have admin closed removal proceedings and people who have outstanding removal orders, USCIS will not approve a nunc-pro-tunc 539. And this is only for nunc-pro-tunc 539s. It doesn't apply to timely filed 539s. That would be a whole nother conversation in and of itself. So I'm just flagging it here for folks where if you've got a client who needs to file a nunc-pro-tunc 539 and they have active admin closed or an outstanding removal order, they're going to have trouble with a 539, and we would encourage you to reach out to us in that situation. Okay. The other thing that USCIS sometimes does require is a demonstration that there were extraordinary circumstances that caused the delay in filing. As I said, for the most part, they're fairly generous about this. So you're going to want to provide some kind of reasonable explanation. But for the most part, these have been going pretty well. Okay. And next slide, please. We talked about this already a little bit. These are some of the really common reasons why 539s are filed late. If folks could keep themselves on mute, please. Thank you. So these are some of the more common reasons that we see for late filed 539s. A lot of times it does have to do with ineffective assistance of counsel. I would also say that particularly when USCIS had just changed their policy and how they were interpreting admission periods for use, right? Like, as I said earlier, for a long time, their position was that even if a person consular processed, the period of admission was based on the approval notice for the I-918 or 918A. They weren't even looking at the I-94. And then when they all of a sudden changed their position on that in 2018, it resulted in a massive amount of denials of 485s on the basis that people were actually not in status, when under USCIS prior interpretation, they would have been in status. And so for those folks, I would say that that could also be an argument for why there were extraordinary circumstances. There also is USCIS error. We've seen cases where USCIS has, for no reason at all, rejected a properly filed 485. We're not even talking about a fee waiver issue. There are all kinds of things that happen with USCIS, right? And so if it's their error, then you can certainly argue that as well. And then personal circumstances of the client. Okay. All right. And with that, let's move on to the next slide. Okay. And just as a reminder, you do not need to file a 539 if you're filing a timely 485, right? We got questions about this every now and then, but when you file a timely 485, the person's U-non-immigrant status is automatically extended. And you can see this in INA 214P6. And you will see in the 485 notice, sometimes they'll put it on the same notice, sometimes it'll be like a separate piece of paper. They'll say that the person's status has been extended. Okay. just a note, don't be confused. If you file a nunc-pro-tunc 539 with a 485, and you get this notice with the 485 receipt saying that the status has been extended, that is not an approval of your nunc-pro-tunc 539. That is an automatic notice that they send out with 485s that can be a little bit confusing. But if you'd filed the 485 timely, then they would automatically extend that status. Okay. All right, and I think that is the end of our planned content, and now we've got a good amount of time for questions.
Thanks, Amy. So the first question is from Emily. She asked, indirect victim question, does the age stay the same if the crime occurred when the direct victim was 8, but the case was not reported and investigated until the direct victim was over 21? So my understanding is the age that controls is the age at the time of the crime, even if the crime was not reported until the direct victim was over 21. Raina had asked, for all California-based practitioners, what is your experience when enforcement agencies refuse to sign a U-Visa certification using SB 674? What is the response on this challenging request? So Raina, sorry, I'm not familiar with SB 674. Is that does that require law enforcement agencies to sign U certifications in certain circumstances? Amy, are you familiar?
Yeah, so I believe that's the California statute on U-Visa certifications. There are a number of states these days, and the number is growing all the time, that do have U-Visa certification statutes on the books that set out particular criteria for certifiers. And so some of them will have a certain time frame by which the certifier needs to respond to the request. Some of them have a presumption of helpfulness. I believe California's does have a presumption of helpfulness. And every state's going to have, their own language in these statutes. They're all going to differ a little bit. So for California, if there are California-based practitioners in our audience today who have experienced pushing back on an LEA refusal to certify, please go ahead and share that in the chat. My understanding is that there is an appeals process, and so I would follow the process that exists. And I know that ILRC has some resources on this. So as we're going through the other questions, I can try to find the link to ILRC's advisory on this and stick it in the chat as well. So if other folks have anything to share, please go ahead.
And Susanna had asked, can victims under 21 include a step parent if married to legal parent at the time of filing? So that would depend on how old the direct victim was at the time the step parent married their legal parent, because they have to be under 18, the direct victim at the time of that marriage, in order for that step parent to be, for USCIS purposes, considered a step parent. If the step parent relationship existed at the time of filing, but not at the time of the crime, you could make the argument that they should still be able to be an indirect victim using the reasoning from that March 2020 AAO case about the adoptive parent. But the position on that isn't like a precedent decision. So I would say look at the age of the direct victim at the time of the marriage of the parents, and then focus on whether you can argue that they should be able to be an indirect victim, the step parent. Diego asked, when are unmarried siblings allowed to get married? Is there eligibility set at the time of filing? So that's a really good question. I have not, off the top of my head, I'm not sure about that. I have seen cases where there's differing interpretations of when the unmarried sibling's age is measured. So there were I've seen cases where the AAO suggested the age is measured at the time of the crime, and I've seen other cases where they mention, where they suggest that the age is measured at the time of filing. So for that, I would probably have to do some research on that question, but that is a very good question.
I mean, in terms of derivative eligibility, the age of the unmarried sibling should be set at the time of filing, because their age should be frozen at that time to preserve their derivative status. In terms of when they're allowed to get married, I haven't seen the memo itself because I don't think USCIS has released it. But apparently there's some 2014 SCOPS guidance that says that U5s, U3s and U5s are able to get married after being admitted in U3 or U5 status without jeopardizing their ability to adjust status. This is policy guidance, subject to change. There's always some risk in following that kind of thing. And as I said, I haven't seen that USCIS has actually released this publicly. I've just seen references to it. And so, advise your clients accordingly.
And then Daniel had asked, is the age of the indirect victim based on the time of the crime or the time of filing? For example, at the time of the crime, a child of the victim is under 21, but at the time of filing, the child is now over 21. So I've seen inconsistent reasoning or responses from the AAO on that particular question, that the time that the indirect victim's age is measured. I would say if you have like a particular specific case question, you could contact us for technical assistance. We can talk about some strategies with that. Catherine had asked, what is the name of the case involving the minor who was abused by his boyfriend? So recently the AEO has stopped, at least for these U visa cases, they've stopped actually naming their cases and they just referred to them with numbers, but that case is linked in your index of materials, which was sent around before the webinar. It's on the second page, number 18, 18D, the October 5th, 2021 case. So if you click on the that hyperlink, you should be able to be taken to that case. Gisela asked, in this example, can the father be included as dependent? So by dependent, do you mean if the child victim were to file his own U visa, if the father could be included as a derivative? You can put that in the chat if you wanted to. While you're doing that, Amy, there was a question about someone has a U visa for 3+ years, but has not gotten their COVID vaccine and cannot adjust. Do you think we could I-539 for many years, or is that very unlikely?
I mean, I haven't seen anybody try it yet, right? And so it's worth a shot. I think it's worth a shot. You could try. I mean, I think we did see a denial recently on a 485 where the person had not gotten their COVID vaccine. And it was denied on discretion is what I believe, Kelly, is that right?
Yes, that's right.
And so, the thing about medical exams and U visas is that the medical exam is not actually like the health related grounds of inadmissibility do not apply, right? And so when somebody is applying for UAOS, they don't have to be admissible. If they don't have to be admissible, the vaccination requirements, which get to inadmissibility shouldn't apply, right? The communicable diseases shouldn't apply, right? All of these things don't apply as inadmissibility grounds. And so my argument would be that the client is actually eligible for UAOS, and it's just a discretionary consideration about whether or not they should be denied adjustment of status for deciding not to get this vaccine, which I think is, I think that there are arguments that they should be able to adjust regardless of whether they've gotten a particular vaccine. So, I think you could try filing the 485 and see what USCIS says about it. You could try the 539, and the thing about 539s is that they're going to be granting them in 1-year increments, and so you're going to be doing this for quite some time, and I don't know what the endpoint is, right? Like, at what point would you not need to file a 539 anymore? When they remove the COVID vaccine from the requirements? I don't know when that's going to happen. So I don't know that you would be able to do a 539 in perpetuity for somebody who refuses to get a COVID vaccine. I would probably try to push back on a discretionary denial of a 45 under those circumstances.
And Raina asks, the person did not apply on time for her adjustment because she had to leave the country. The father of her children threatened to sue her because she brought her children without his consent. She got scared and went to fix that problem in her country originally. When she tried to return, CBP did not let her enter the country. Could she file an I-539 based on special circumstances?
I tend to think that in this situation, she might actually need to consular process. I think my concern is that because if she was never, it's not clear from this fact pattern whether or not this person has a valid U visa, right? Visa as opposed to status. If she doesn't have a visa, then she's not able to come back in. And she is going to have to consular process in order to get the visa. The questions then is going to be, how is she going to get this visa when her approval notice has expired? And this is one of the tricky situations that we have because of this USCIS interpretation of the amended approval notice issue. I mean, I think you could try to get them to issue an amended approval notice without a 539. My concern with filing a 539 is because she's out of the country. I don't know that they're going to grant it because she technically doesn't have status to extend either. But if you want to talk through like the specifics of this situation, feel free to submit a TA. We'd be happy to chat about it with you.
The next question is, could an I-539 be used to request that an approved U visa be updated to reflect a client's new legal name, or is there a different form that's used for that purpose?
Would you be, I mean, it's not clear to me, would the 539 be used just to correct the legal name?
That was my understanding of the question.
Okay.
Can you use an I-539 for that?
I don't think you need to. I don't think that's necessary. That seems like a lot of trouble to go to correct somebody's legal name. I think if the only thing you're trying to do is correct their name, you can submit evidence of the name change to USCIS and ask them to update their records to reflect the new legal name. If you need a new EAD, for example, then I would file a 765 and request a replacement EAD and provide evidence of the legal name change.
The next question is, when would be an appropriate time to file an I-539 for a petitioner who is waiting for their derivatives to consular process in and requesting the amended approval notice? Should it be done a few months prior to the use status expiration date or as soon as possible?
So that's a great question because we have conflicting guidance from USCIS on this. So if you look at the 2016 U visa extension memo, it says that you should file it within the 90 days prior to the extension of status. But if you look at the 539 form instructions, and remember the form instructions are regulations, right? They have been incorporated into the regulations. And I would say they would trump the policy memo. The form instructions say that you should file the 539 as soon as you know that it will be necessary. And so I would say that you can file this as soon as possible. And I would recommend that because 539s take a long time to be adjudicated. And if you need a new 765 in conjunction with the 539, you want to reduce that gap in employment authorization as much as possible, right? And so I would file that as soon as possible. We have heard a few reports here and there that the mailroom has rejected some of these that were filed more than 90 days out. If you have that problem, let us know. We can see if there's something that we can do to help escalate it. But I would file it as soon as possible.
The next question is, if the principal and two derivatives who live in the United States need to extend status based on the same circumstances, meaning not able to adjust yet, do you file an I-539 for the principal and I-539As for the derivatives?
That's right. Yeah, since everybody's in the United States, they're all in non-immigrant status. They should all be able to file together and should be able to save some money by filing the derivatives as 539As.
Someone asked, is a misdemeanor assault, non-family violence / felonious assault an eligible crime for the U? So that's a good question. That depends on how misdemeanor assault is defined in that particular state. If you could argue that it is that it's similar to, for example, maybe how felonious assault is defined federally, but that's a question that if you have that particular issue, I would recommend contacting us for TA on that. Let's see. Someone asked, is it better to file for a minor under 7 years old whose parent was killed as a direct or indirect victim? That's a great question. So I guess the issue with indirect victim is that you still have to make a showing that they have cooperated with the law enforcement investigation. If you're unable to show that, I think it probably make more sense to file as the direct victim, because if you're a direct victim and you're under 16 at the time of the crime, then you can have someone else provide information or cooperate on your behalf under regulation. But I don't believe that's available for indirect victims. Amy, do you have any
I'm
thoughts?
just looking up the regs right now to check it, to see what the exact language is. So I'll do that while we talk about the next one. So if you take a look at 214.14, it's 8 CFR 214.14 B2. This is what talks about the cooperation requirements for U1 petitioners, right? And they don't talk about U1 petitioners in the context of direct victims exclusively. It's just a requirement for all U1 petitioners. And so I would make the argument that if you have a 7-year-old whose father was killed, I would make the argument that the minor is an indirect victim, because I think that's going to be more straightforward for USCIS to understand. Like, generally speaking, these direct victim arguments I think are great and have a lot of potential, but they're really, really hard for USCIS to get. And so if you have a more straightforward argument, which I think in this case would be an indirect victim argument, that's probably what I would present first. And then with respect to the helpfulness to law enforcement requirement, I would look to see whether or not there was somebody else, a parent, guardian, or next friend, who could possess information and be helpful to law enforcement on the 7-year-old's behalf. And I would argue that it doesn't matter whether it's a direct or indirect victim.
Makes sense. Someone had asked, can someone in each of the siblings file separate U visa applications when the victim was mom who was murdered by boyfriend and all of her children are adults and lived separately but in the same town? All were close to mom but lived separately. Separate. I think, so I mean, if they're assuming these are all, yeah, all children are adults, so assuming that they're all adults, they wouldn't, for example, be able to include their siblings, if they're over 21, at least, they wouldn't be able to, include siblings, as derivatives. I think in that case, you would have to make the direct victim argument in each separate U visa application. So I believe it would have to be, multiple separate applications. Does that make sense to you, Amy?
Yeah, I mean, if these are adult siblings who are over 18, they are not going to be eligible to be derivatives on each other's applications, right? So I think they would all have to be filing as principals.
Someone asked, client leaves the US while in U status and then enters without inspection to come back. Have folks had any success filing I-539s to get clients back into U status after they have abandoned their U status as a result of them leaving and then entering without inspection?
I will open this up to the audience. If folks have had success with this, please put it into the chat. I think historically there were folks who did have success in doing this. This also was the strategy that a lot of folks followed for example, derivatives who never consular processed after approval and just e-weed. And they were trying to get them into status, right? I would see it as a very similar issue. The problem for me when I look at this is that a 539 is for either changing from one non-immigrant status to another, or one non-immigrant classification to another, or extending non-immigrant status. And when you EWI, you are not in any kind of non-immigrant status, and so you're not changing from one to the other. And you don't really have one to extend either. And so that's why I think this 539 strategy is, for me, the dots don't line up. I know that in practice, people did this for a long time and it seemed to be working. I think people were able to adjust based on this strategy and it was working for a long time, but I think it has been less successful in more recent years. If you were able to get USCIS to reissue an approval notice with an I-94 on it, then I think that would actually fix this problem. But the question is whether or not you would be able to get them to do that. Your other option is to have the client consular process, as they should have done to begin with. But again, if other folks have had other experience with this, please do share it in the chat. This is a really, unfortunately, common scenario.
Someone asked, is there a time limit to file a nunc-pro-tunc I-539?
No, I mean, once you're untimely, it's untimely. So no, there isn't. I think the thing that you're going to run into is that the longer it's been, the more USCIS might expect in terms of what is the reason for this delayed filing, right? Because under that regulation at 214.1, they do sometimes look for extraordinary circumstances beyond the control of the applicant to explain the delay. They're often not really sticklers about that, but sometimes they are. I think if you're looking at a really long delay, you would want to document it even more thoroughly why this was being filed late.
And sorry, go ahead.
Sorry, go ahead.
And someone asked, it's a great question, how long does it take to get a U visa receipt notice after it has been mailed or filed to USCIS?
A long time. So we have done a couple calls for examples on the listserv. You guys might have seen them. So this is a very common problem. We've seen it at both Nebraska and Vermont now. It's not clear what the source of the problem is. We've reached out to USCIS a few times. Other advocacy organizations have also reached out to USCIS. You know, everybody knows about it. It's just not clear why there is this problem and why it's taking so long to fix. So I don't know. It sometimes is taking several months. What I will say is that in the vast majority of these cases, USCIS does eventually issue the receipt notice. And so we're not recommending refiling at this juncture because that seems to create even more confusion. And feel free to follow up with the hotline. Like, I think it's a good idea to follow up regularly with the hotline on these missing receipt notice cases, but they will take a long time. One thing that I have not tried, and I don't know if anybody else has tried this, is some of the problems with these receipt notices appear to be linked to delays in fee waiver adjudications. It seems to be more likely that you get a delayed receipt notice when you file it with a fee waiver. And so one thing that I have not tried, and I'm very curious to see if this would work, would be if you filed a 918 or the 918As without a 192 or a 765, because the 918 and 918As don't require a fee. And I wonder if they would go ahead and receipt those in. And then once you get that receipt notice, you could supplement with the 192 and the 765, and then you can let those receipt notices take as long as they take. Because the key is getting that receipt notice for the 918 before the cert expires, right? And so I'm curious to see if that would work. If anybody tries it, please let us know.
From the chat, someone had asked, do you have a guide on ASISTA that talks about the inadmissibility grounds that do not apply to U visa holders? So when applying for the U non-immigrant status itself, the grounds of inadmissibility do apply, but a waiver is available for almost all grounds of inadmissibility for U holders, except I believe it's participation in Nazi persecution, genocide, torture. That's at 212D14, and that lists the one ground of inadmissibility that can't be waived. For U visa adjustment applicants, INA 245M allows for adjustment for U holders as long as they are not inadmissible under that same ground, 212A3E. The actual language is that if the allows for adjustment, if the non-citizen is not described in section. So that means that that is the only inadmissibility ground that applies at adjustment. The rest of them do not apply at that time, but it's important to get all grounds waived at the time of U visa filing, because if they're not, there could be an argument that the U itself was granted unlawfully.
And then for the U visa itself, there is one ground that doesn't apply. The only one is public charge. All of the rest of the grounds do apply. So
thank you.
And I see a note here from someone that they had a client who refused to be vaccinated, and USCIS asked for an I-601 waiver. And if this was a U visa client, that is incorrect. USCIS should not have asked for a waiver. They could have denied it on discretion, but they shouldn't have asked for a waiver.
And then someone had asked if a U visa applicant needs to exit the country, once the U visa is approved, can they consular process? So if they left the country, they would, and they're an applicant, they would have to notify USCIS that they are now out of the country. So USCIS knows that the approval has to be sent to the consulate. And then if they incurred any inadmissibility grounds by leaving the country, like for example, the unlawful presence ground at 212A9B, they would also have to either file an I-192 or amend their 192. But yes, consular processing is how they would enter with the U1 non-immigrant status. Making sure we don't have any additional questions. Someone asked, I had a case where we had no receipt, tracking number was not showing as delivered, reached out to Nebraska Service Center on the hotline, and they said they had no record of the case being filed. Yeah, I've heard about that. I begged law enforcement for a new certification, and they gave it and refiled, got the new receipts. 18 months later, the first U visa filing receipts came. Not sure how that is going to play out, but there it is. Yeah, that's a good example.
Yeah. I would want to make sure that those first U visa receipts from the initial filing were receipted in on the correct date. And then as long as that happened, then they're supposed to be going first in, first out. And so hopefully they would be going based on that initial filing date instead of the second one.
Sandra had asked, client was riding bike home when suspect running away from law enforcement hit him with a vehicle. Suspect was being investigated by DDEA and had a warrant for their arrest. Client was hospitalized. This was in 2016, filed for you. USCIS asking for additional evidence. So I would say you can contact us for technical assistance on that particular question, since it's a case-specific question. You can you could schedule a technical assistance appointment on our website.
And
So
I think that
that's
brings
all.
us to 4 o'clock, right?
Yes, right. So that is all that we have. I'm just quickly putting in the chat a link to register for our September webinar, which is about representing U-Visa clients with complex issues. So I'll quickly put that in the chat box. And thank you so much to all of you for attending. And please remember to fill out the evaluation. Mary Kate really helpfully put the link to that in the chat. We do use the evaluations to help us plan future trainings. Thanks everyone.